So even though on the screen you see two Stephen Richmans, one of us, I'm the real one. The other one is Will Phillips. And then we have Felix, Prozorov-Bastians, Felix. And what we're going to do is go through about 12 or 13 slides. We encourage you to send your questions to us by the chat, and we'll try to integrate them as we go along. What we're going to do as well is have one of us will introduce a slide and then the others will comment. So what we're talking about here, I'll just do the first introduction and then Will and Felix will comment on this and then we'll move on. We're talking about what excuses performance under a contract that you're otherwise meant to be held to. And we talk about this doctrine of force majeure, which is essentially an escape hatch for performance under certain extreme conditions that are essentially unexpected or unforeseeable and beyond control. We talk about acts of God or things like that. This is a common law doctrine, common law countries, and I believe that Felix will talk about a civil law equivalence. In order to think about force majeure, there are two historic breakdowns of it. One is the notion of impossibility, where your performance is excused if the subject matter of the contract has been destroyed. Generally, it doesn't have to be an absolute complete impossibility, but it's a pretty high standard. And then the other aspect or doctrine is impracticability, which basically indicates that it's too expensive or too hard to perform based on the unforeseen events. These are narrow doctrines, and we'll talk a little bit later about what is and is not impracticable. Many courts in the US will use impracticality and impossibility in the same way, but the concept is you are unable to perform no matter how much you try, even if it costs you a little more, because it's going to cost you more than that. It's going to be essentially impossible or impracticable to perform for reasons outside your control. And the last excuse is frustration of purpose, where you can perform, but the reason for performing no longer exists. And the classic example is somebody had tickets to go see the coronation of a king, and the king was sick, so the coronation was canceled that day. This person still could have gone to the stands and sat there, but there would have been no purpose for it. And that's a simple way of looking at frustration of purpose. Will and Felix, do you want to add to this slide?
I would add, thanks, Stephen. I would add only the fact that force majeure really is grounded in contract. It is a standard contractual provision that's included in a lot of contracts, and it is enforced more or less like a contract clause. And we can get into what that means exactly later. While the doctrines of impossibility, impracticability, and frustration of purpose really have to do, at least in common law countries, with things that are not in the contract themselves, but are supplied by the common law.
Maybe then also from myself, I don't know whether I can see for all civil law countries, but at least for Germany, yes, the force majeure concept is as well has to be provided for in the contract, and the doctrine of impossibility and frustration of purpose is something that is set forth in German law. There is maybe one additional mean of dealing with impossible or impractical performance in German law. It is the concept of lack of fault for the breach of contract due to consequences beyond somebody's control. So we'll come to that later.
And Will's distinction is a good one. When I was talking about force majeure, I was speaking generally. If you have it in the contract, you can tailor it, and we'll talk about that otherwise. If you don't have it in the contract, then you're relying on common law principles like we discussed, and they have other factors that you may want to address when you draft. So, Will, maybe you can talk a bit more and take the lead on this slide about force majeure clauses.
Certainly. And force majeure clauses are enforced like other contractual provisions generally. And what that means is that most courts will uphold them if by their terms, by their literal language. And therefore, whatever the event is that is stopping performance needs to be contemplated in the express language of the contract. And there are courts which say no, the possibility of a devastating fire is not contemplated in the language of the contract itself, so that event is not covered by a force majeure clause, because these clauses tend to be read very strictly by courts. That being said, catch-all general provisions that describe general events that make it clear that events of a particular nature will prevent performance are upheld from time to time. But courts tend to look at these doctrines on force majeure clauses very narrowly. And in fact, if you look through the jurisprudence in the US at least, you'll find legions of cases which deny the applicability of a force majeure clause, and very few which in fact honor it, because, as I said, I think courts take a very skeptical view of it. A couple of other things is the slide notes, the performance is excused only where there's a causation between the event that is contemplated and the performance. I give an example that we ran into recently. A regional airline was suing with regard to a financial contract, saying that the COVID epidemic was preventing its performance, and the court held that no, it wasn't preventing the performance at all. It was the airline could still fly, it just didn't have any passengers because of COVID. So. That's the sort of example where a force majeure clause will not help you. One last comment, which is that if you've got a force majeure clause, the courts will tend not to look at impossibility or impracticality as well, just because a lot of courts look at it and say, well, you've contemplated under what circumstances impossibility becomes a defense, and we will observe the parties' agreement on that rather than the common law doctrines.
Yeah, and that's very good. I would add a couple of points on this. I think when we look at a force majeure clause, not every contract will have it, and particularly if you are in a sale of goods situation, you'll have in the United States, the Uniform Commercial Code, which has its own statutory force majeure clause we'll mention later. But if you are going to do it, think about it as a risk allocation clause. You're basically held to your contract, as we've said, but under certain circumstances, the parties are agreeing what essentially would be the risk allocation, what circumstances would allow you not to perform. And you would also want to include in your force majeure clause certain types of notice provisions. You would want to think about whether it's a full or a partial excuse for performance. If it's a partial excuse, how long will you tolerate the partial excuse before it's deemed full? You really need to give thought to it. And the last point I would make on a force majeure clause is be careful when you're drafting. If you want to identify 49 items very specifically, you may have gone too specific. So the 50th item that isn't exactly mentioned may be deemed by the court not to be there. On the other hand, as Will's has pointed out, a more general clause might be helpful, because as long as it's particularly described to accommodate the type of situation. And very importantly, again, if you're opting for the contract as opposed to relying on other principles under law, you will want to make sure. Oh, I just lost my thought. If you're opting for the contract, I'm sorry, I completely lost my thought there. Go ahead, Felix, if you want to add something.
I think the next slide deals with the German angle, so I will just wait for a minute. And a couple of things. So I fully agree from the point of view of German law, it is quite dangerous to make the force majeure clause too specific, because if it is specific, of course, it will be interpreted also in German law very narrowly. But in German law, the solution may be if you can convince your contractual partner to agree to make the force majeure clause very, very vast, very broad, because there is a definition of German courts given to the force majeure, and there is also plenty of cases dealing with this. And the reason is that the force majeure is mentioned actually in German law, not as an excuse to impossibility or to wrong performance, but in the framework of statute of limitation. Because if you have a force majeure event during the last 6 months of the statute of limitation, the statute of limitation stays for the time of force majeure. So once it is mentioned in court, in law, the courts are forced to make a definition, and they made quite a clear definition. As in, the event has to be external, has not to do with the party, not foreseeable. It shall be very seldom, so not reasonable, preventable, and should be unavoidable. So the practical tip from recommendation also from the point of view of German law: do make the force majeure clause not too specific.
I remembered my thought, and that was on the force majeure clause. You're not concerned with foreseeability because you are identifying specific incidents. And the only other point I was going to make, instead of using a force majeure clause, it may be that you can think about using conditions in the contract, an if-then approach. What we will talk about is that financial hardship by itself or change of economic conditions of the contract will not necessarily, will generally not give you an out under force majeure. But if you want to deal with the possibility that something will become more costly, you can deal with it elsewhere in the contract. And I really wanted to make the point that a force majeure clause in a contract should not be looked at in isolation. It needs to be considered with the rest of your contractual terms. Impossibility of performance provides relief where the force majeure, as Will mentioned, force majeure clause is your option instead of relying on the common law. We've talked about objective impossibility. It can't be a subjective issue. There was a case where somebody was concerned about a terrorist attack and therefore did not perform, and the court had indicated this was not objective. This was not going to satisfy the strict terms of, at least in the US, of impossibility of performance. And again, if you're not relying on your clause, but on the common law, it has to be an unanticipated event that could not have been foreseen. And again, as I mentioned, and as Will has said as well, in the US, economic hardship is not enough by itself. However, if it becomes extreme, you know, it's not just a few extra dollars where you're obligated to try to perform under the conditions, but it becomes a massively expensive situation. There are courts that will accommodate that. I should note at the end of these slides, you'll see about 4 or 5 cases in the United States where they dealt with it. COVID has not changed the dynamic or the principles. And as Will also mentioned, there is still the causation factor. And there are a few cases there where people entered into settlement agreements in cases as COVID was breaking. And then as the government shutdowns came and they felt their businesses were hurt, they couldn't perform, they went into this, the courts have indicated, with eyes wide open. This was not unforeseen, and it was not an excuse there. And they, in one instance, there was a question too as to whether there was even proof that they could not find the money elsewhere or accommodate the COVID situation by bringing in extra money. Will and Felix?
Yeah, the causation point is really important to stress here because, as I said, these cases, particularly on impossibility, are few and far between that actually where courts relieve performance because of impossibility. And one of the most common reasons is the causation between the impossibility and actual performance. So again, if the airline is failing to honor financial conditions or compacts or something because of COVID, if it's because it doesn't have any passengers, that's not causation because of COVID. If it's because a government regulation comes down and says you shall not fly, then a contract for the airline to fly would be rendered impossible.
Yes, it is pretty much the same under German law, and with the difference that in German law, this defense is provided in law, in German civil code, and it is an impossibility of performance. It is a kind of broader in the sense that if nobody can procure the good on the market, it is an impossible. Or then there is one thing we also mentioned in the framework of force majeure clause. Of course, if the force majeure clause is in the agreement, the court may come to the conclusion that the parties covered all possibilities of impossibility in the force majeure clause, so they might not rely to the impossibility defense if the force majeure clause is in the contract.
Will, you want to take the lead on this next one and then comment?
Yeah, the impracticability of performance is another variant of the doctrines that relieve performance because of external unforeseeable events. But again, it's in my experience, it's even more limited. There are some, this did not intend to be an entire U.S. state survey, but I looked in particular at Delaware and California and New York. Delaware and California observe impracticability as a defense to performance. It's not available in New York, and I'm sure there are other jurisdictions besides New York where impracticability does not relieve performance. But as you see, the test is really one of where performance becomes unreasonably expensive and excessive. California law also has something which I think is akin to what Felix has been saying about German law, which there's a temporary impossibility. Most of the time, impracticability and impossibility used to relieve performance altogether, not just suspend it. In California, at least, you can temporarily suspend it, in which case things like the statute of limitations become important.
We have a question, but Felix, did you want to comment first, and then I'll go to the question?
Yes, in impracticability of performance, this defense is available under German law, but also already noted, only if the performance becomes extremely unreasonable, like the procurement costs now the tenfold of the agreed price.
Yeah, there was a case that I had read. It was an arbitration decision, and the issue was one party needed to ship to another party, and because of government action in the particular country, the port that entity usually shipped from was closed. So the alternative was to travel to another port. It would increase the expense, and the party was trying to claim impracticability. And the court looked at a variety of law, US law, European principles, civil law issues, and concluded pretty much what we're saying, that the party has an obligation to try to perform. We've mentioned in one of the slides obligations to mitigate damages, and even though it would have been more expensive, that party still could have performed by going to the other port, even if it costed some money. That wasn't the extreme situation. There have been other situations I've seen where maybe it was 500–600% increase in cost, where that was deemed to be the kind of excessiveness that was mentioned. The question we have is, has any of the panelists used the ICC model force majeure clause recently updated to address hardship? And if so, do you find it helpful in the international context? I would note, I've not used it, but I also note that it's important to think about choice of law provisions in your contract too, because as we've noted and has been pointed out, different states have different variations. In the US, different countries will have their variations. So simply using a form clause without tying it to a particular choice of law may impact its interpretation, but I've not used it. Will and Felix?
I've not used it either, but I think your comment is well taken, particularly even when it comes to something as simple as the way courts will read exactly the same contract provision. Different courts will read them very differently depending on the doctrine of law. So choice of law is extremely important in this.
Felix, any comment on that question?
No, I haven't used it as well. And of course, I agree with you. Important are also the other provisions of the agreement, because these specific laws will be interpreted in light of the entire agreement, and under German law, also in light of entire circumstances surrounding the agreement.
Now, the next thing, we've talked about impracticability and impossibility, and basically something unforeseen that comes up and you're unable to address it. Now we have where you can do what you're supposed to do under the contract, but the reason for doing it, the frustration of purpose, has precluded it. And again, this, as was mentioned, if you've adopted for a force majeure clause, some courts will still allow you to have this defense. I've seen it litigated. I think in Illinois, for example, Judge Posner has indicated that you can't have it if you've adopted for the contractual remedy. Depends where you are. But I would ask too, in terms of the frustration of purpose, I haven't seen this case litigated. Many of us had planned to attend certain bar. We were planning to go to Moscow. Let's suppose you had booked your flight to Moscow for this conference. Then the conference is canceled. The purpose of the flight was to go to Moscow to participate in the conference. The airline is not going to refund your money. It maybe will give you a credit. Maybe it'll charge you change fees or not. Do you think that would justify a frustration of purpose in terms of your contract for your ticket with the airline?
I have to say, I don't think you'd win that case. And the reason I don't think you'd win that case is because I don't think it was a shared purpose by both of the parties to the contract. From the airline's perspective, the purpose of the contract is to get you to Moscow, and they don't really care why you're going. And my experience with this clause is that it's narrowly construed. It's rarely really successfully invoked, and it really has to be where, like your example of going to a coronation or going to a football game where you've got tickets to the seats, but the football game isn't going to be held because the season's been canceled. But in that case, both sides of the contract would agree that the essential purpose of the contract has been frustrated.
That's a good distinction. I'm sure that's a question many people in the legal profession are asking, as we've all had to change our things. Felix, anything to add?
Yes, maybe the frustration of purpose is only also available of German law, even though it has a slightly different angle. And but I tried not to make out of the German defense a special one, because I think it is fairly similar to the common law concept of frustration of purpose. In German law, it is set forth in law, and it sounds like vanish of the basic circumstances both parties rely on. So in this definition, what Will said, it is also covered upon that it should be mutual, and it should be really basic to the agreement, and it should really frustrate the purpose of the agreement. Just to take your example, like flying to the Moscow and the conference conference is cancelled. So it would not be frustration of purpose, but imagine there is no, I don't know, the city of Moscow is underwater now. The entire city is underwater except of the airport. So in this case, it might be the frustration of purpose, because there is no purpose at all flying to Moscow, because you cannot get out of the airport.
You want to take the lead, Felix, on this particular slide, German law, no fault?
Yes, so it is just an additional angle, because in the beginning we had a summary of defenses which we can use to heal the impossible performance under the agreement. So there is one peculiarity of German law which gives us an additional, or gives the necessity to use this additional defense, no fault, because German law is designed that way that if the performance is impossible, it is only means that the party is free to perform in kind, because the party in Germany has to perform in kind. So if you have to deliver a car, then you cannot say, I'm not willing to deliver the car. The other party can sue you and can get this specific car from you. So if it is impossible to deliver the car, it is impossible, but you still might be liable for not being able to deliver this car. So we need in German law this specific additional approach to say there is no fault for breach of the agreement, no fault for the impossibility. Of course, the criteria is pretty much the same, which we are discussed in the framework of the impossibility of performance, and it is particularly important for wrong performance or late performance, because if the performance is wrong somehow because of circumstances, because of COVID-19, the performance is made, but performance is wrong. So then it is, under German concept, you will not speak about impossibility, you will speak about no fault for this specific breach.
Will, anything to add on this?
No, I don't. I find it very interesting that German law sort of incorporates this whole issue in just looking at breaches with the concept of fault and no fault. Yeah. And we had a request that I change I just figured out technologically how to change my name, Stephen. So
okay. The only comment I would make too is to reiterate something I said earlier on the last point, approach relevant for late performance and wrong performance. Again, people should not look at the force majeure clause as a magic bullet, and you have other clauses in your contract. If there are particular things, particularly if you have an industry specific contract, there are different kinds of events that can occur that may not be foreseeable in one industry context, but are in another. Think about writing your contract to address these issues short of the force majeure remedy. You know, if there is late performance, if there is this, based on these incidents, then this will happen. I always recommend an if-then approach to think through, rather than just trying to rely on a so-called boilerplate type of clause. Again, we talked about the use of a clause. If you are not relying on and do not have a force majeure clause in the contract, but in the United States, you're dealing with a sale of goods that would bring you under the Uniform Commercial Code. I have a typo here. It's 2-615, not 1615. Then the Uniform Commercial Code talks about impracticality. And again, it talks about compliance in good faith with a foreign or domestic regulation that causes you not to perform. This is interesting because it includes words to the effect that even if it's later invalid. So if you look at the cases at the end of the slides, which we'll touch on, even if there is a government order, first there has to be the causation, and you have to be complying in good faith with it. If you still can perform under the contract, you can't simply rely on the government rule. For example, in the United States, we've had certain closures of businesses, but certain activities are permitted, like a restaurant that can do takeout if it could not have in dining. So there was at least one case where in a rent situation, the debtor claimed its business couldn't perform. It was dealing with the shutdowns. The court looked at when the shutdown occurred, what the impact was on the business, and whether or not perhaps a pro rata reduction in the rent would be appropriate, because it could comply with its contractual obligations to some extent. If you're outside the United States and you're dealing with a cross-border situation where businesses are part of and governed by the CISG, the United Nations Convention on Contracts for the International Sale of Goods, Article 79 refers to an impediment. And if you read the history of that, it was deliberately using that word to avoid concepts of impossibility or impracticability. And it talks about whether or not the impediment was beyond control and could not reasonably have been expected to occur. And then finally, in the United States, as a general proposition, it's not law by itself unless a court adopts it, but a kind of treatise or restatement of the law for persuasive purposes is our Restatement Second of Contracts. And this talks about impracticability without your own fault. Dealing with a non-assumed event, there is your foreseeability issue, unless the language or circumstances indicate that you would have the ability to take this defense. So I cite these basically to talk about the different words that are used: impracticability, impediment, impracticability without fault.
And I think your comment on the non-assumed event is another important one, besides the issue of causation, which is always an issue in litigating these cases. Whether or not the event was covered by the risks that were discussed and assumed within the contract, either explicitly or implicitly, is usually very important to the determination of whether or not impossibility or impracticability are going to work here as a defense to performance.
Felix, how does this resonate with you as a civil law practitioner in Russia or Germany?
One thing to cover this statutory issue, it would be interesting to know whether in other countries did it as well. In Germany issued a specific law covered several COVID-19 issues. For example, there was a problem like a statutory stay of a payment obligation for lease contracts. So the lessors, the lessees had the right to retain payments on lease contracts, on specific lease contracts for a specific time during the pandemics. And it was also a provision on the consumer loans. So the consumer loans were also stayed for repayment for several months. And it is something special. It would be interesting to know whether the United States issued similar laws.
Any other comments? Okay. I put this slide in because I think, and I won't spend a lot of time on it, but I want to flag the issue. You know, what if you're wrong? If you claim something as force majeure and it's not, you yourself may be in breach of contract if you've guessed wrong. So this is essentially a warning and a practical tip. Many people have run to look at COVID as a silver bullet or a magic wand to get them out of a contract because they're having some hardship. But if you can perform, and as we've talked several times, you're obligated to perform, and as Will has mentioned too, there's a strict, a narrow construction of these clauses, and courts will try to hold you to it. You can ask, or you may receive a request for performance. You want to be specific. You don't want to simply assert a general inability. If you really feel you can't perform and are asserting force majeure, I would suggest, at least in your notice, you be more specific, because you can risk setting yourself up for anticipatory breach. The other side then can say, well, you're claiming force majeure, we want assurance that you're going to perform, and if you don't provide it, they may declare you in breach. So you need to, again, understand that a force majeure clause is not in isolation. There are other contract principles at play, and if you guess wrong, you may be liable.
Yeah, and I think you put your finger on the dilemma that I know a lot of the people that I consulted with, particularly at the beginning of the pandemic, at least in the US in March, were grappling with, which was, you know, a lot of people wanted to know, can I assert force majeure? What happens if I assert force majeure? And it's not risk-free, because you might end up in a lawsuit over anticipatory breach, which you don't want. I'd say the vast majority of clients we had that considered force majeure or the doctrines of impossibility or impracticability use this as part of a negotiation to come to a negotiated solution, and didn't end up litigating it. As I said, the results of litigating these issues, it doesn't usually go well for the people who are claiming it.
And the practical solution, I've heard that from other people too, in some cases, both parties were relieved that they didn't have to go through with the contract. Right. Felix, any comments on this?
No, I agree with everything.
So, Will or Felix, do you want to take this slide?
Well, I mean, I think that one of the first things, the first bullet on this, distinguish between COVID-19 and the government acts as a causal factor, is very important. It may well be that you have force majeure or impossibility because of the government action. To say that COVID-19 itself has caused it, I think, is usually a tougher argument to make, because it's usually the actions that are taken in response to it that cause the impossibility, not the disease.
Felix?
Maybe I will take the third bullet point, this German angle. So it asks who defines what is pandemic or epidemic. So for Germany, the question seems to be clear, because the SIRS 2002 was seen as a force majeure, so which is capable of being force majeure, and to be a pandemic. And so everybody is actually thinks in Germany that COVID-19 can be potentially seen as a force majeure, but of course, you need a lot of another circumstances. You need the causation, you need the relevance, and you need the really affection of the agreement.
And even if you are, I mean, I did find one case at least, although it may be industry specific, that talked about jawboning, you know, government actions. At what point, even interpreting the government action, can you or can you not perform? And you were always under the obligation to try to perform. So you do run into these gray areas where it's not clear. My only other comment on the third point is I've seen clauses that talk about a pandemic. I've seen them that talk about an epidemic. I just, how much more broadly do you describe the situation, and how it becomes a drafting issue too, to try to anticipate the next COVID perhaps. In the final moments we have about 8 minutes left. Maybe we can just give you an illustration of some cases, and then the panel and the audience can comment on them. These are not all the COVID-19 cases. There may be a couple others, but I think they do demonstrate what we've said, the strict interpretation. In this first one from May, the defendants failed to establish their financial difficulties out of the COVID epidemic, and that it adversely affected their ability to pay. Therefore, their settlement agreement obligation was not excused, even though they said by closing us as a non-essential business, we were harmed. I mean, from the panel's perspective, then it becomes a matter of proof. How much in your view, is burdensome? You know, is it like 30% ability, 50%? You know, we're told restaurants can now operate maybe at 25% capacity, but restaurants are on tight margins and may not be able to survive that. How do you advise a client in these situations? What do you think the rules of thumb are, or are there any?
I think it's all depends on the context. And it depends on what the obligation is and what the excuse is. You know, failure to be insolvency, near insolvency are very often not excuses to financial performance. Just like insolvency is not in the US, in most states, is not a justification for injunctive relief. And so, you know, but if the obligation is not just one that's affected because the restaurant can only seat 25%, but because the restaurant needs to have a wedding party for 100 people and can only allow in 25, then I think that is something that in fact really is truly affected by it.
Felix, any comments?
In Germany, you in order to solve this case, you have to come from the different side, because in Germany there is a basic principle of law, sounds like you shall have money. So there is no excuse for not having enough money.
Right.
So for whatever reason. So if you want to somehow solve this case, you have to argue that we have to adjust the agreement because of the change of the circumstances, so that my obligation to pay reduced, because I can never argue I don't have enough money to pay.
So that was the problem too in the next case cited there. They didn't meet their high burden to show that the financial difficulty excused performance. Again, I think it comes back to the original point too. You're dealing with allocation of risk. You make your contract. You should give some forethought to things. In a volatile industry, maybe you want to consider conditions. You know, if the cost of this goes up by a certain amount, then we renegotiate, or this happens. You know, but you've dealt with it at least.
I think to some extent, Stephen, your next case, which is the in-ray hits case, is, and maybe that's not the screen that you have up, is one of the interesting ones, because it's something that, you know, I would think these cases would be filling up the courts right now, frankly, because every landlord-tenant case in the country falls in some way into some place on the spectrum of this. And, you know, this is a case in which the force majeure clause was upheld, but not completely, because you know, it was given some effect, but not a total effect.
Yeah, see, that was interesting here. The court looked at the good faith obligations on each side, and it did enforce the force majeure clause, but it didn't find the facts justified a complete excuse. And it's also important to realize, you know, landlords may be held at the same level as used car salesmen, but they do have creditors too. And, you know, they have obligations that they're held to up and down the stream. Felix, this particular case, is this consistent with how you think a German court might do it? Look at the, sort of come to a fair solution and give a pro rata type of result? Do we think courts are going to be looking at the magnitude of the COVID-19, and even if it doesn't change basic contract principles, try to achieve some fairness at the end of the day?
It is very difficult. As we also discussed, all those excuses we discussed are very limited. So if you don't have a force majeure clause in the proceedings, it is very difficult to argue, especially in the lease contracts, that the performance is in relevant way affected by COVID-19, because there is also an important issue to consider whether the parties expressly or tacitly allocated the risk of the use of the lease premises in the agreement. So the German court approach would most probably be that the lessor shifted his risk, the risk of using the premises to the lessee. And it was all the reason for German government, for German parliament to issue a law allowing the lessees to stay their payments for a specific time, because it was clear that it would be most probably very difficult, if not impossible, by law.
It's just important also to go back to something that Will had said in the second slide, dealing with crafting your force majeure clause. You know, here, the clause said, lack of money shall not be grounds for force majeure. And I've looked at commercial leases where, notwithstanding all the force majeure excuse language in there, they also say this won't excuse rent. You know, it can excuse other performances. Now, this is a negotiated line in your document, and this particular clause refers to orders of government. So in some ways, the parties allocated this risk up front and now are being held to it. Although, as indicated, there were certain facts and there were the language of the government shutdown is important from the causation issue. What exactly could they and could they not do? Unless there are questions, Victoria, which we can't see, maybe each of the panelists could give a concluding comment. Like a best
I think we have to close the session in 1 minute.
Right.
If I interpreted our schedule right, maybe a couple of closing remarks.
Good, that's what I'm saying. Go ahead.
No, it is just from me. I would like maybe you would like to wrap up the session.
Okay. Will, anything final tonight?
I just think, look, it's we've obviously gone through a lot of the big principles. The cases always lag the principles, so it'll be interesting to see how this turns out. As I said, my own experience is a lot of people are trying to negotiate around these issues and not litigate them for the very reasons you pointed out, Stephen, in terms of the risks. But I do think that particularly in some particular industries and contexts, and landlord-tenant is one of them, I think we'll be seeing new law made out of this, just like, you know, whenever there's a financial shutdown, we find new law made in the bond markets. And but when you have a once a century pandemic, we're going to find force majeure and doctrines of impossibility are going to become more developed in our law, and my bet around the world.
I think that's right. The cases have supported the basic principles of contract law, but in most prior situations, it wasn't this global situation, and you may start to see, you know, fact-intensive results like in the Hitz case. They're still enforcing the law, and ultimately it may be matters of statutory reform that address things in the future. So we're closing at 10:01, and I want to thank the audience and the panelists.
We have one more question here.
Okay.
Don't you think that impracticability element is very ambiguous, as it can't be specifically defined, and also it is very subjective? I agree that my own thought is that it is ambiguous, and I think that's one of the problems that courts have with it. As I said, it depends on what jurisdiction you're in as to whether or not impracticability will be recognized as a defense.
I don't think it's quite as subjective when courts are I mean, if it costs you an extra 10% and you think that's too much, a court will look at what becomes extreme, but I would agree it's a sliding scale and there's no set factor.
We've also got a request to make the slides available. I don't know what the answer from the organizers is. I think all of us are probably completely fine with making them available.
Okay. I think we're done.
Thanks, guys. Thanks, everybody.
Thank you.
All right.
Thank you.
Thank you.